I appreciate that. So. Involved in
So
this.
it's nice.
Sleep well.
Minneapolis.
That's good.
(5:31). Will you go ahead and do a roll call for us, Cassidy?
Mandy Folks? Here. Julie O's?
Here.
Shelby Poole?
Here.
Ryan Sheep? Natalie Schulberg? Here. Julie Scordo?
Here.
Rich Washington?
Here.
And Natalie, will you read the mission and vision?
Yes. The mission of WLA is to utilize leadership-based programs and strategies grounded in solid research, combined with the demonstrated success of core knowledge curriculum as a basis of a rigorous overall educational program that builds strong skills in math, reading, literature, writing, music, science, and technology. The vision of WLA is to be a school where students and graduates become exceptional leaders and are prepared to take on the academic and leadership challenges they will face in high school and beyond.
Thank you. And Mandy, if you would like to
I would
present.
love to make a motion to approve tonight's meeting agenda.
And second.
Second.
We have a motion to approve tonight's meeting agenda. All in favor, say aye.
Aye.
Opposed, say no. Any abstentions? Motion carries.
And then I would like to also make a motion to approve the August 24th, 2022 meeting minutes.
I'll second.
Okay. There's been a motion and a second to approve August 24th, 2022 meeting minutes. All in favor, say aye.
Aye.
Opposed, say no. Any abstentions? Motion carries. Are there any conflicts of interest tonight? We do not have any public comments.
I do want to say just real quick, I think, so Steve was sitting out here by the door to let people in, and I said, did you put a note on the door over there to tell people to come to the store? And he said, oh, I didn't do that. So he went down the other door. So if we can have people come in, and
We might
you might
review.
just
Okay.
circle back to that.
Okay. And our board training is not present yet either.
So I say we maybe just get past it, we can always come back.
Yeah.
So let's just go to 7 and then we can swing back when Jim's here, because he might be one of the people that is.
Stuck at the door.
Oh, yeah, we did that.
I'll wait and see who that is.
Okay, yeah. Okay. Remember to
Ask for a
motion
motion.
second, and then you say, any further discussion.
Further discussion.
And then you probably want to invite Jim up here. Jim Martin, who's our lawyer back there, when he's ready to go.
Jim, if you want to join us up here.
That's all right, I'll just switch water.
All right.
Thank you.
I guess online they can't hear anything. I don't know what something was said yet.
So for those of you just joining us, apologies for the door confusion. We are at point 5 on our agenda, the public comment. So now that there is public comment, just want to remind you that you will be given 2 minutes to address the board. We will not engage in discussion or debate, but we'll take the information and find answers if appropriate. Just a reminder not to include names of school employees or titles, names of students, for their legal protection and the legal rights of staff and students. If you have issues with the employees, it should be made to school administration. So we have Ryan Patrick, who would like
First off, the timing has not been consistent across meetings. There's video to prove that. I'd like to talk about enrollment trends, though, as they relate to the budget. Last year, we came in at 635 ADM, which was 7% below projected forecast used to secure our debt. This year, we're coming in at 690, which is 11% below the 774 projection used to secure our debt. This relates directly to the lease aid payments that we receive, which are the lesser of a fixed amount per student pupil, or 90% of the lease expense. We anticipated that by this time we would receive 90%. Due to declining EDM trends, we are on track to receive around 80%. I'm wondering what the board is doing to review and look at these analytics. I asked about it when I was on the board. Mr. Livingston asked about it at his last meeting. Andy Folks said at both meetings that this is something important the board needs to look into. We'll do analytics, we'll look at it. Over the last 18 months, I have not seen any of that. What is the board doing to take its fiduciary responsibility seriously? At the last July meeting, the board approved a Monarch bus contract along with the budget. The Monarch bus contract was significantly higher than what was in the budget. I noticed that flipping through the pages. Did any of you look at that? As a parent, I'm very concerned about whether the board is reviewing and taking into account these documents that are serious documents. The Monarch bus contract is the largest one that you guys approve. A question was asked at that board meeting by a board member. Did we receive other bids? To which Mandy Folks replied, we typically have received higher bids, so we didn't this time. Is the board just completely ignoring its fiduciary responsibility? And what is the board going to do?
Thank you. And there is no other public comment. And then our next item on the agenda is our board training. So we would like to welcome Jim to join us, and
Good evening.
Good evening, welcome,
Do we
Jim.
have the slides up somewhere?
Which one are you
Right there.
starting with?
We're going to start with the open meeting law. Good. Great.
And Jim, if you want to introduce yourself, I don't know that all the board members
So
know
can I
you.
stand here? Is that-
Absolutely, you can stand, sit, yep,
Great. I'm going to grab one of these.
yep.
So my name is Jim Martin, with Martin Law Firm. I'm one of the lawyers representing Woodbury Leadership Academy and have been working with the school for a number of years. I've been practicing law for 30-plus years, primarily employment law. I've worked as a school HR director for 12 years at a couple of school districts in the Twin Cities. And so my practice is primarily representing school districts and charter schools, primarily in employment law matters, board issues, board governance, and any other things that might pop up during the day, week, year. So I appreciate the opportunity to come today and talk to you about a couple of topics related to board governance. One of them is the open meeting law, and we'll talk a little bit about that. I think, I'm thinking maybe, 45 minutes to an hour, is that enough? I mean, I can certainly streamline it if you want to, but we'll cover it as best we can, and I can certainly, for questions, I just want to make sure that I'm not interfering with the rest of the rest of the business you have at the meeting.
Well, I think we kind of set it, we assumed you'd be an hour, so we kind of shortcut it some other
All right.
things.
One other thing I have a side gig also. I've, for 20-plus years, I've been an adjunct professor at the University of Minnesota, where I've taught a course on school HR administration for licensed staff who are working on their administrative license. So a lot of this I've dealt with, particularly the data practices. So those are my credentials for what it's worth. So open meeting law, let's start with that. This is something that all board members should be aware of and understand, and I think it's not always understood by school boards. So Minnesota Statute 13D, Chapter 13D, is the statute that governs the open meeting law. And if you look at the Minnesota Charter School Statute, Minnesota Statute Chapter 124D, it states specifically that boards of charter schools are subject to the provisions of the open meeting law. So you've got to follow this. So we're going to kind of walk through that. So, great. Okay, next. There's my disclaimer. This is not legal advice. I'm just giving this as an oversight, overview of the open meeting law. So requirements, next. Okay, what is the open meeting law? Statute that applies to public bodies. Requires that public bodies conduct business in an open meeting that we'll discuss and provide more detail under the statute. And an open meeting under the open meeting law is one which happens when proper notice is given, and we're going to talk about notice for different types of meetings and what it entails. That the public may attend, then that the public has access to relevant documents. We're also going to talk about situations when meetings can be closed as well. So next, please. All right. So let's talk first about what the open meeting law requires. It requires that any votes be taken at an open meeting and that the record of the votes be kept in a journal. So the open meeting law doesn't talk about the fact that you have to have minutes. There's other provisions in other statutes that require the detailed minutes, but the open meeting law doesn't say anything about minutes. It just says that a vote of the board has to be kept in a journal. And the votes have to be taken in an open meeting. Yes, ma'am.
Do they have to be printed or can they be online in a journal?
That's a good question. I think probably I would want to keep a hard copy, but they can certainly be kept electronically, and they can be viewed electronically and remotely by people, by members of the public. But I would suggest keeping a hard copy on file as well.
Jim, do you know if the minutes suffice for that? Like, could it just be the minutes as long as your votes are recorded in there?
I would submit that it probably can, yeah.
Okay.
The minute-
That would cut down a lot of work for us. Yeah, okay.
So votes are taken in open meeting there. There we go.
better?
Yeah,
Thanks.
thank you, Julie.
Thank you. The other thing that's required is that the copies of the agenda, at least one copy of the agenda and any materials that the board is reviewing has to be made available to members of the public that attend the meeting. Just, on the back table, I mean, I saw you have several copies, which is great, but the law only requires that there be one copy available in the room. Same materials that the board has, with the exception of non-public data. So if you're going to be dealing with something that's non-public, a personnel matter or something, or student matter, something like that, that's not something that the public gets. And other materials related to a closed meeting, that you don't have to provide that to the public as well. So notice requirements. Let's talk a little bit about what the notice requirements are under the open meeting law. And there are 3 types of meetings that are governed by the open meeting law, and so they have different types of notices. So we're going to go through each of those. A regular meeting is your regular business meeting, either once a month, twice a month, depending on the school. There is regular meetings. The only thing that has to be kept in terms of scheduling a regular meeting is a list or schedule of the regular meetings kept in the main office of the public body. You don't need to post it every time if you don't want to. You just have to keep a schedule on file at the regular meeting. Now, if you're going to change that, if you're going to change the date, the time, the location of a regular meeting, then you have to post that as you would a special meeting. And we'll talk about posting for special meeting. But the standard for posting, scheduling for regular meetings is pretty straightforward. It's your first business meeting of the year. You say, we're going to hold meetings on the 3rd Thursday of every month at 5:30 in the boardroom or wherever you're going to hold them at the school. And all you have to have is a sheet of paper that has that schedule that's accessible to the public during regular business hours. And that's all you need to notice regular meetings. Now, practically every public entity that I work with, they do post the regular meetings. They post the time, date, location of the regular meetings, and usually they post the agenda as well. And I think that's, in the interest of accessibility, I think that's a good thing to do. It's a good practice, but it's not legally required. So regular meetings are just your regular business meetings. There are also special meetings. So as things come up, there might be a time when you have to call a special meeting. Now, under the special meeting provision of the open meeting law, you have to provide at least 3 days' notice. And the special meeting notice has to indicate the date, time, location, and the topic or topics to be covered during the special meeting. And those are the only topics that can be covered during a special meeting, are those that are contained in the notice. It has to be 3 days prior to the meeting, has to be noticed. And also, if you have received requests from individuals, usually it's like the news media, and there's some members of the public who want regular notice, you have to also provide those individuals with that additional notice as well. Or you can publish it in the local paper if they're going to get it out 3 days in advance. But so that's the standard for special meeting. we're going to talk about the next emergency meeting, so the next is emergency meeting. And this is where people, board members get confused. They think that, something comes up and, let's call an emergency meeting. Well, the scope of what's allowed to be called for an emergency meeting is really narrow. You can only call an emergency meeting in a situation where there's like a pandemic, terrorist attack, some type of, significant emergency like a water main break, things like that. So really dire emergencies where you can't wait 3 days for the board to take action. So during the pandemic, a number of schools that I work with were calling emergency meetings on how to address the pandemic and what they're going to do in terms of addressing the pandemic. That would be a situation that would allow an emergency meeting. Same thing, you want a date, time, location, topic of the emergency meeting. You post it, you make a good faith effort to notify everyone who's requested notice of emergency meetings, and you do the best you can to notify people. And then again, the emergency meeting, you can only discuss the items that are identified, the topics that are identified in the notice of the emergency meeting. Yes, ma'am?
So, can you clarify why you would ever have a special meeting? Why wouldn't you just have another regular meeting instead of once a month? If we wanted to meet, 3 weeks from now, why wouldn't we just schedule what's so special about a special meeting?
Well, it's things that really can't wait a month. So I'm thinking about, in my circumstance, because I do employment law, there's a number of situations where you call a special meeting if there have been allegations or charges against an employee.
Gotcha.
And the board needs to meet about that. Or there have been allegations or charges about, any employee, the executive director, a teacher, another administrator, and there needs to be a meeting of the board. Usually it's going to be at least initially closed for preliminary consideration of allegations against that individual. And then the board decides, okay, we need to hire an investigator, we need to conduct an investigation. And, so that's a situation, you can't wait 4 weeks if you've received some significant allegations against an employee. You might be in a situation, if you've got a real estate matter, where, you've received an offer, you can't wait for the next business meeting to address or respond to that offer.
So I just want to clarify, if we know we would need another meeting before our next meeting.
Yep.
And you're in this meeting and you schedule it, then it's a regular meeting.
Nope.
Oh, it's
No,
still a
it's
special meeting. So if it's
meeting
outside
because-
of your calendar.
Right,
It's
if
special.
it's outside of your
Perfect.
outside of the calendar that you set at the first business meeting of the
Okay.
year, where you said we're gonna
Perfect.
hold business meeting every third Thursday of the month, that's a regular meeting. If
Okay.
you are sitting here and you say, hey, you know what, a week from now, we need to schedule an additional meeting because we have to discuss something, then you notice the meeting, you have to provide at least 3 days' notice,
Yep.
date, time, location, and the topic of the meeting.
Okay. Got it.
So anything that's outside the regular schedule.
Okay.
And again, if you alter the regular schedule, I just had this question come up from a client yesterday. They wanted to move the location of the regular board meeting. And I said, well, then you have to notice it just like a special meeting, which is 3 days' notice, date, time, location, and then the topics. You just put the agenda out there that was, the agenda for the regular meeting.
So I think we just treat basically every meeting as a special meeting, and we just send notice 3 days before.
Yeah.
Typically what we do. So
Yeah.
cover our
Yeah.
bases.
Right, and a lot of schools do that.
Yeah.
They just do
Okay.
it just to make sure that the public is notified.
Yeah, great.
One other quick one, inclement weather, like let's say we get a blizzard on a board meeting day and we have to cancel, then we're okay to just reschedule that meeting as a regular meeting?
Reschedule it, and you could do one of two things. You could come to the regular meeting, because we'll talk about that. You could come to the regular meeting, you get a quorum, you call the meeting to order, and then you recess it. And then you would put out notice that it's because of inclement weather, the meeting's been recessed to another date. That's one way to do it. The other is you'd have to figure out some way to notify the public that because of the weather, you're not going to hold the meeting, and then you reschedule it, but you reschedule it as a special meeting, as opposed to a regular business meeting. Recessed meetings, so let's say that we're in this meeting, or we're in a special meeting, and, the presenter talks way too long, and it gets too late, and you have to, you have to recess it to reschedule it. It can be taken up without further notice, as long as you've established the date, time, location of the reconvening of the meeting. But I would, again, best practice, I would just repost, note that there was a recess meeting, the board is reconvening at a particular date, time, location to complete the business begun at the meeting on, that was recessed.
Okay, Jim, I missed that. So you have to give 3 days' notice of the next, when the recess is going to pick up?
No, I'm only
Okay.
saying that's best practice. Recess meeting, this just says it can be recessed meeting can just be reconvened without further notice, as long as the board identifies when it recesses, when they're going to reconvene. But again, in the interest of making sure everybody's notified, it doesn't hurt to, post it, like you would a meeting, but you just call it a reconvening of a recessed meeting. Or something to that effect. And then we'll talk about closed meetings and the reasons for closing meetings. But if you're going to have a special meeting that's going to be closed for whatever reason, same thing. You can note date, time, location, topic, which would be closed meeting for pursuant to 13D.05 for a personnel matter, for evaluation, for attorney-client privilege discussion, for real estate issue, for security briefing, any of those reasons, you do that. Now, again, this is like, there's, technicalities to it. If you're in a regular meeting like tonight, and a topic has come up that you want to close the meeting, you need to close the meeting. You can amend your agenda, amend your regular meeting agenda, just to add a closed portion of the meeting. And you go into closed session, then you come back. But if you're going to hold a special meeting that's going to be closed for whatever purpose, then you notice it just like you would a special meeting. Okay, makes sense? Everybody?
So we could know that something's coming up, something occurred and we're gonna wanna close a meeting. So, and we're meeting tomorrow, regularly. So rather than notice, we could just amend the agenda that evening for a closed session.
No, if you're regular, tonight's your regular meeting, right? Let's say that yesterday you found out about some allegations against an employee, that you need to close the meeting. And you don't need to wait 3 days, you need to take care of it right away. You could go into meeting tonight, during the call to order and then the approval of the agenda and minutes. Somebody could say, Madam Chair, I move to amend the agenda for a closed meeting pursuant to 13D.05, subdivision 2B, for preliminary consideration of allegations against an employee. Second, voted on. And so at that point in the meeting, you would, the board chair would read a statement saying we're going to close session pursuant to 13D.05, say all the magic words, and then you go into closed session, you have your discussion, you come back, and then you proceed with the rest of the meeting. Okay, all right. Okay, and then I talked about, so the closed meeting, and then before the meeting and during the meeting, you have to make a statement that provides the grounds for permitting the meeting to be closed and a description. And again, those are the magic words I was referring to. Closing the meeting pursuant to 13D.05 for preliminary consideration of allegations against employee, or closing the meeting pursuant to 13D.05 for evaluation of an employee by the board, which is usually the executive director, or closing the meeting pursuant to 13D.04, I think, for attorney-client privilege discussions, or closing the meeting, you don't have this because you don't have labor unions, but closing the meeting for union or negotiation strategies. Or if you've got a real estate matter that has to be discussed during a closed meeting, you close it for that reason, or for security briefing. So you have to say, we are closing the meeting pursuant to the statutory citation for this reason. Yes?
Are board members considered employees?
It depends on the school, but most are considered employees. Because if you're getting, you're not getting paid,
Well, I would be an employee, but
you'd
like,
be an employee.
you wouldn't be. She.
Yeah, our non-teacher board members are not paid.
Yeah, well, but like independent school districts, the board members are considered employees because they're receiving pay, they're getting W-2s. Some of them, some schools allow access by board members to have access to health insurance. For the most part, they're typically characterized as employees, though.
We're not paid for being at these meetings, we're paid to be teachers.
Right, I understand that, but
Still
there's,
considered
In
employees.
this kind of,
Okay.
I guess, for a closed meeting to discuss, like, employee,
well, it would be
Evaluation.
an employee, not a board member. It would be a non-board member employee, typically. When they mean
so not
closing it,
discuss.
they say it's for, well, actually, the actual language of the statute says, closing the meeting pursuant to 13.05 to discuss allegations against an individual subject to the board's authority. So it could be a board member, there could be allegations against a board member, and you close the meeting for preliminary consideration of allegations against an individual subject to the board's authority. A board member is subject to the board's authority.
Okay. Exactly. Thank you.
Okay, any questions about notice requirements? Okay, what is a meeting? Got a kind of a series of questions about what are considered meetings. So workshops, informational meetings, where the board receives information, like for example, a lot of independent school districts have 2 meetings a month. They have a business meeting, and then they have a workshop. And the business meeting is obviously what it is, a business meeting. The workshop is usually where the board will do a deep dive on 1 or 2 or 3 topics, but not take any action. But it'll be an opportunity for administration to provide significant information so that at the next business meeting, the board might be asked to consider some action related to items and information that was brought. So any of those information meetings, even if there's no votes taken, those informational meetings are still considered board meetings that are subject to the open meeting law. If there are facilitated meetings to improve trust, relationship, communications, like a board meeting, get together, just to try and work better together, that is not considered a meeting under the open meeting law, as long as you're not conducting any school business. You're just there to hash things out and to learn to work together better. That's not subject to the open meeting law. Are committee meetings considered subject to the open meeting law? Typically, yes, even if there's not a quorum of board members. So if you've got a committee, a finance committee that's made up of maybe 1 or 2 board members, but also members of the public, other staff members, maybe the business manager, formal committees, personnel committee, policy committee, those meetings are probably, since the information that they provide and the recommendations that those committees provide are many times considered and approved by the board, those would be considered meetings that are subject to the open meeting law. So that's, so committee meetings, yes. That's all right, no, you can go back, you can go on. So advisory groups, though, and there's a distinction, and this, it's a case, the case that kind of creates that distinction, it's the Minnesota Daily versus the University of Minnesota. And that case was a situation where the Board of Regents established an advisory committee to help it with the search for a university president. And and this was made up of students and faculty and members of the public and I don't know who else, but they were, just there to gather information and provide guidance and to, provide input to the Board of Regents in their selection of the university president. And Minnesota Daily said, hey, this is a committee, it's subject to the open meeting law, and what the court said, that since this board did not have any decision-making authority, all it did was advise the board, and then the board made the decision. It's not subject to the open meeting law. And also, it was not a standing committee. It was put together for a particular purpose. Once that particular purpose had ended, it was no longer in effect. So unlike a regular standing committee, an advisory committee is not going to be subject to the open meeting law. Social gatherings.
Can I ask
Yes?
you a quick question? Back to just regular committees, like our governance
Yep.
committee?
Mhm.
So like, are the same like notice requirements then? So like special committee meetings?
Right.
Okay.
Yep, same, yep, if you're a committee, if you're on a committee or if a committee is subject to the open meeting law, then all the rules, regulations, requirements of the open meeting law apply to the committees, which may include, closure. So if you've got a personnel committee meeting and you have to deal with a personnel matter, you might close the meeting for that, pursuant to 13D.05. Social gatherings. Social gatherings typically are not considered meetings, but if you're if you're going to be at a social event and there's going to be a quorum of the board, you can certainly meet, but make certain, I'd say, try and stay in separate corners of the room. Don't gather in a corner and talk and look over your shoulder and like you're trying to hide something. But social events where there's a quorum of the board are not subject to the open meeting law, but you want to make sure you're not conducting any business. It's going to make you exempt from a situation where there's a social event. So I think about my kids either have gone or they go to Hopkins now, and Hopkins Education Foundation has a big fundraiser every year. The board shows up, and invariably several of them will get together and talk and socialize and all that. And, just so long as they're not conducting business during this social event, it's not going to be considered a meeting under the open meeting law.
I'm sorry, I have so many questions. Can you define quorum? Like how many?
Quorum would be,
Is it 2 or 1?
it would be 51%. So you've got 6 members.
We have 7. We have one
Seven.
You have 7, so 4 would be a quorum. If you have 9 members, 5 would be the quorum. So it's 51%.
In a previous life,
Yes.
if board was to meet together, we would just notice it if we thought we were gonna have a forum at an event. Is that unusual?
Well, but you'd have to notice it as a special meeting. So you'd have to say date, time, location, and then what's the topic you're going to discuss. And, you're going to, are you going to meet in the back corner of the hall or the banquet room? And then what are you going to discuss? So I would say don't notice, if there's a social event, don't notice it, because if you notice it, there's going to be an expectation that the board is going to be conducting business. You're not going to be conducting business. Some may not even be in proper shape to conduct business. You never know, depending on the social event. Okay, a couple others. Emails. My former colleague Laura Booth, she said, email is the tool of the devil. I would be very reticent and careful for board members to be emailing each other about topics that are being discussed or topics that are before the board. Because, and we'll talk about this a little bit later, but you do not want to be engaged in situations where you are discussing matters via email and then you come to a board meeting and there's some action taken, and there's not robust discussion occurring at the meeting because all the discussion has occurred via email. So I would submit and suggest that you not, if you receive email from a board member, that you not respond or engage in discussion. Usually what I suggest, if a board member is going to use email, or Dr. Mortensen's going to be using email, that it's used to provide information and just say, hey, for the next board meeting, here's some things that you need to be aware of. Or we're going to be in closed session about allegations against an individual. Here are the facts that you're going to be dealing with at this closed session. And then don't respond, don't engage, don't discuss, just, accept it and use it as a method of delivery of information rather than, US mail or something like that.
Does
Yes?
that have to be like, if we send an email, whatever information was provided to everybody, does that then have to be included in like a packet or like given out to the public before the meeting, or no?
If it's
Just
going to
use
be, if it's going to be part of the packet that's provided to the board at the meeting, then yes, unless that information would be considered non-public and is the subject of a closed session of the meeting, then it wouldn't be provided to the public. But if let's say you're just in an open meeting and you're going to be discussing some matter, and Dr. Mortensen has received some more information from like your auditor or something like that, said, here's some more information for you to consider as we're talking about this particular finance topic, then that's going to be included as part of the packet. So emails, it could very well, emails could result in a meeting that's subject to the open meeting law. If there's discussion going on amongst board members via email, that is then used to make a determination and used for a vote. Social media, posts on social media, probably not. I would say likely not. So one of the things, I'm going to just pull up the statute here. Minnesota, I wish I didn't bring my glasses, I wish I brought them, but Minnesota statute 13D.065, there's a specific provision in the open meeting law that talks about use of social media by board members. And this states that the use of social media by members of a public body, you're a public body, does not violate this chapter, so the open meeting law, so long as the social media use is limited to exchanges with all members of the general public. For purposes of this section, email is not considered a type of social media. So if you're on Facebook, LinkedIn, TikTok, whatever you're on, if you're using social media to interact with the general public, that is not considered, doesn't have any connection to the open meeting law, and the court and the legislature has said that use of social media is not a violation of the open meeting law. Now, typically not, but if you are using social media to communicate with members of the board, just limiting it to communication to members of the board, then you might very well run afoul of the open meeting law. So it's okay if you want to publicize stuff on social media, but if you're going to do that, you should not be disclosing non-public data about students. You should not be posting photographs of students unless it's directory information. You should not be disclosing information about employees, non-public information about employees. You can talk about all the wonderful things that are going on at Woodbury Leadership Academy and the events that people should be looking forward to and that type of thing. But it's not meant to be an opportunity for you to talk about non-public data, non-public information. Okay. Serial communication, we talked about that. Does the open meeting law apply to serial communication amongst less than a quorum? And it might, if less than a quorum, then this one part of the board that's less than a quorum talks to another one or two board members, and it becomes now you've got a quorum discussing a matter that should be covered at a meeting. That would be seen as serial communication. That could be a violation of the open meeting law. You're conducting business outside of a meeting governed by the open meeting law. Again, we talked about that in terms of email. One-way communication is probably going to be okay. But again, it's going to be printed material that might be in the agenda, and you have to make that available to the public. So you want to be aware of what you're sending and the sensitivity of it, and that anything, you want to make sure that if you're going to use that and it's going to be considered printed material, that any non-public data is going to be redacted from anything that is made public made available to the public during the meeting. So, one way is permissible, no decisions, no discussion going on. Again, like what I said, a board member might be sending information to the board for consideration. Dr. Mortensen might be sending something to the board for consideration, but as long as there's no back and forth, you're not going to be in violation of the open meeting law in that regard. Okay, closed meetings. When can you close meetings? There are a number of meetings when must be closed. So 13D.05, there are times when board meetings must be closed. So if you're going to be discussing allegations, alleged victims of sexual violence, domestic violence, maltreatment, criminal sexual conduct, if you're going to discuss that, you must close the meeting. Must close the meeting. If you're talking about an active criminal investigation of one of your employees, must close the meeting. Educational data. Well, educational data is data about students. Public health data about individuals, public medical data, welfare, mental health data, anything that has to do with those types of things related to individuals, you have to close the meeting. Now, you could have a discussion about, non-personally identifiable information. You could say, these are our trends related to COVID, or these are our trends related to the flu, or something like that. As long as you're not saying, these individual students all have COVID, or these individual staff members have the flu or something, you can't do that. But if you're going to be talking about particular individuals who have these health issues or mental health issues or anything like that, you must close the meeting if you're going to discuss them, if the board's going to discuss them. An individual's medical record, and then this is the one that comes up for me primarily a lot, is the preliminary consideration of allegations against an individual subject to the board's authority. So there's allegations made against an employee. You close the meeting, the board discusses them, they hear about the allegations, and then there's a decision made to investigate or a decision made to discipline. After you've made that decision, where the outcome following that meeting may result in discipline, or discipline may occur, all further discussions have to occur in open meeting. And I'll talk a little bit about how you can discuss that, or why you can discuss things like that in open meeting. But for preliminary consideration of allegations or charges, you must close the meeting. Now, the little footnote at the end, any of these situations where the meeting must be closed, if the subject of the data wants to have the meeting open, they can do it. I've had situations where there have been allegations made against an individual, and they have decided, you know what, I want everything aired in public. I want the public to know what's going on. If they say they want the meeting open, then they can open the meeting, and the board has to open the meeting for them. But if the subject of the data doesn't open the meeting, then it's got to remain closed. Okay, next please. When meeting must be closed, it's declining to renew a coach, dismissal hearings of a teacher, expulsion hearings. If the board is presiding an expulsion meeting, that's got to be closed as well. Next, please. All right. Okay, when meetings may be closed, it's optional. So if you had a union and you were going to be discussing labor negotiation strategy, you could close the meeting if you wanted to. To evaluate the performance of an employee, you may close the meeting. If you close it, then at the next open meeting, the board has to provide a summary of the evaluation. And it's not just, the summary can't be as simple as, employee A is doing a great job. It's got to be a fairly detailed summary of all the things they're doing well, the things the individual's doing poorly, what their plan is, or their work plan is for the next year. All that would have to be disclosed at the next open meeting.
So Jim, excuse me, so may be closed. So if the board's evaluating my performance, they can decide if they want it closed or not?
Well, you can have it open if you want.
I don't want it open, but if
Yeah,
I did,
Then I would say they should keep it closed.
okay. But they can choose whether they want it open or closed.
Well, they may close it, but I think because of the language, I would never advise a board to conduct an evaluation in an open meeting unless the subject of the data asks for it to be open.
And I say that because I have experienced years and years ago with a colleague that had things in an open meeting. It didn't go well.
At their own choice, though.
And it wasn't at their own choice, but it was a different school, a different era, a different
Yeah,
decade, actually.
Well, the other thing, I'll talk a little bit about how discussing what would you normally think would be non-public data. There's some exceptions to that. We'll talk a little bit about that.
Okay.
Attorney-client privilege may be closed. To receive security briefings, if you, from the police or someone, that would be closed. And then everything, whenever you close a meeting for any reason other than for attorney-client privilege discussions, you have to record the closed meeting. And then you have to maintain it pursuant to the Data Practices Act, or the open meeting law. So, we're talking about the situation where you close a meeting for preliminary consideration of allegations, and then following that closed meeting, it's determined that you're going to investigate. That means that discipline may occur, and all further discussions have to occur in an open meeting. What allows that is this provision right here, that it says data. So what it means is that data that are not public may be discussed at a meeting without liability or penalty if the disclosure relates to the scope of the public body's authority and is necessary for the public body or the board to conduct its business or address an agenda item. Oversight of employees is certainly within the purview of the board. That would mean that after you've had the closed meeting for preliminary consideration of allegations, and you've decided that discipline may occur because you want to investigate, or you're going to, you've given that individual a notice of proposed termination or something like that, you can discuss that in an open meeting without liability or penalty because that's part of your job. Now, the copies of any data, so anything in writing, that's still subject to the Data Practices Act. So you may not be able to disclose that, but your discussions in the meeting are okay. The data itself, the underlying data, letters or documents, or that is still going to be covered by the Data Practices Act and may possibly not be disclosed. Okay? Okay, violations of the open meeting law. You have to have intent. You have to show that there was an intention to violate the open meeting law. So if you're at the social event, for example, and 5 of you are in at the social event, and you make a decision on something you're going to do at the board. If there was no intent, you can show there wasn't. It was inadvertent that a decision was made. That's not a violation. It's got to be an intentional violation, and those are the only ones. And even then, the penalties are like not too significantly severe. $300 for each single violation, and then after 3 violations, the board member can be removed. And then also you have to pay the costs and attorney fees for the board member who violated has to pay costs and attorney's fees. So those are the penalties. And I would say that most boards that I've worked with, and actually even a lot of the case law that I've seen, a lot of the administrative opinions that I've seen over the years, there's not a rampant epidemic of people who want to, who get on boards and they want to conduct all these meetings in secret. It's mostly inadvertence and not knowing. Like the one that I get a lot is they'll say, well, we want to discuss the executive director's contract. And, maybe they work in the private sector and, the CEO's contract is typically not discussed in public. And so they think, we don't want to do that. It's, nobody's business. So we're going to, close the meeting to discuss the terms of the director's contract. That's not allowed under the open meeting law. So that's not really an intentional violation. That's more of like kind of a violation of inadvertence or, lack of knowledge. So, those are examples. And so I would say, as long as you're making a good faith effort to try and comply with the provisions of the open meeting law, you're going to be in pretty good shape, I would say. Is that the last one? Okay. Any questions? I think we covered, I know that there was your authorizer wanted some specific information about emails and about social media. I think we covered that, unless there's more additional questions about that. Any other questions about the open meeting law?
Just a question in general about the presentation. Will we receive a copy of like the slide deck that we can reference back to?
I've sent it to...
Perfect.
Cassidy?
Yep.
Was it to Cassidy?
Okay.
Sent it to Cassidy. Yep, so it's there.
Thank you.
All right.
Okay, we're going to talk about data for school leaders. Now, this is really not a topic that the board deals with in great detail, but I think it's important for the board to understand the Data Practices Act and FERPA, just so that you can understand what the staff is going through, and to a certain extent what your obligations are as board members in terms of protection of data. So again, there's my disclaimer. This is not advice. So let's talk about the underlying public policy, underlying the Data Practices Act and underlying FERPA. Everybody know what FERPA is?
No.
It's a acronym for, it's like the Family Educational Something Privacy Act. Can't remember what they are.
It's probably rights to privacy.
Right.
Yeah. But it's a federal statute that governs the privacy of student data. And it applies to all entities that are receiving any money from the federal government. So it applies to school districts, charter schools, colleges, universities, any entity, any school, educational entity that's receiving federal funds. And then the Data Practices Act is a state law that governs all manner of data at the state level. So everything. I mean, we're talking all state data. So conviction data, arrest data, health and human service data, personnel data, court data, anything that any government entity in Minnesota that collects, maintains, and distributes data is all governed by the Data Practices Act. So the public policy underlying data practice law, what is that underlying policy? And it's to create a balance. It's to establish a balance of the public's right to know, because the public are taxpayers. They have a right to know how their government is operating, how their tax dollars are being handled, versus an individual's right to privacy. So, if you're an employee, how much should the public get to know about you as a public employee? How much should the public get to know about you as a student? That's the balance. That's what these statutes are attempting to do, is balance the public's right to know versus an individual's right to privacy. We're only going to talk about two aspects of data practice, and that's personal data and educational data. Like I said, there's all sorts of other types, but we're only talking about two. Okay? So the general rules for education and personal data. When I say education data, I would interchange that, it's education/student data. So education data, they call it education data, but in fact, it's really student data. So the general rules, the primary general rule of the Data Practices Act is that all government data is public unless there's a provision in the law that makes it private or non-public. So everything's public unless there's an exception. For education, student data, and personnel data, it's just the opposite. Everything about students, all data on students, all data on employees is private or non-public unless the statute identifies data, a piece of data that's public. Understand? We got that? And then the primary rule that I ask everyone to follow is to consider that you'll be very careful in the disclosure of any data. Make sure you're on solid ground before you disclose data because you cannot unring the bell. Once you've sent the data out, the bell has been rung, you can't get it back, and there's trouble ahead. So be very careful about disclosure of data. And I would suggest that it is better to err on the side of caution in disclosure because the penalties for non-disclosure are much less severe than the penalties for wrongful disclosure of data. So those are the general rules. So let's talk first about the general rules for personnel data. Personnel data is governed by, there's no federal law that governs personnel data of state government, of schools. It's only the Data Practices Act. The statute that governs personnel data under the Data Practices Act is Section 1343. And basically what that says is the following data on public employees is considered public. And then there's a laundry list of items that are public. So gross salary, wage range, job assignment, work email, work phone number, work location, any prior employment, their education background is public, including the schools that a public employee attended is public. If there have been any complaints or charges against a public employee, that's public. Just the existence and status of complaint is public. Any discipline that an employee has been subjected to is public. So those are kind of the main areas that are considered public. So wages, benefits, education, existence and status of complaints, discipline. Those are things that are always accessible. You can always, if someone were to call here or come by and submit a written request, I want all public data on employee X. The school is obligated to provide the person requesting that with access to that data on employee X, all public data. Another way that public personnel data can be provided is by authorization of the subject of the data. So let's say that someone comes in, they say, I want data on employee X, and employee X signs an authorization and says, I authorize you to provide my entire personnel file to this individual. You can do that. Also, if there's a court order that requires the school to disclose data, non-public data, and this is not just a subpoena, this is an actual court order. And the way that this usually comes up is in litigation, when a public employee is involved in litigation with an outside third party. They get into the discovery process. The adverse party to the employee wants to see their personnel file. The employee says, no, I don't want to give up my personnel file, it's not relevant. And a judge will, there'll be a motion to compel discovery, and the judge will order disclosure of the personnel file. Mm-hmm. That's the type of court order we're talking. A subpoena alone is not sufficient. So those are situations. Mm-hmm. That's all right. Those are important provisions about personnel data.
Jim, if someone requests Jolene's universities that she's attended, let's say, and then I provide that information, does Jolene get to know, or is there an obligation to tell her that someone has requested, or does that just
There's
stay
no
quiet?
obligation that you notify the subject of the data that there's been
Okay.
a request.
Thank you.
I mean,
But she could
She could.
notify Jolene?
Yeah, if you wanted to, but there's no the statute, Data Practices Act does not require that you notify the subject of the data that there's been a request. I mean, think about all the data that is maintained by school districts and by other entities within the state, to have to track down every subject of the data every time there's a request for data would be be an impossible task. So there's no requirement that the subject of the data be notified. I think the assumption is, the understanding is, if you're an employee, a public employee, you know that, your certain data about you is public and it might be provided if it's requested. I think that's kind of the understanding.
That can be provided
My
to,
background that I wouldn't want recorded, but if somebody's snooping around on me and my current employer knows that they're asking these questions, I would want to know.
Well, maybe your employer could do it, but if they're asking for public data, they're asking for.
Right. And I understand the release of it, but just.
It just gets tricky because, we're all sensitive, human
Right,
beings, it's a-
Yeah, if the school wants to, if the school wanted to establish a policy or practice, that every time someone requests public data on a member, on an employee, and the school wanted to establish a policy or practice that allows for that disclosure, they can do it, but there's nothing that requires it.
Requires it, yeah.
So these people that are requesting data, does it have to be like a member of our school community, or can be someone from any state, from anywhere,
Anybody.
stalking me,
Anybody.
saying, I'm going to call up, I think they work there, I need their records. So
Well,
anybody could do
But all they're
that?
gonna get, if it's somebody, from another part of the country that's asking about, you say there's, you're saying they're stalking you, they're not gonna get, they technically, under the law, they should not be getting home address, home phone number, social security number, anything about your family. They're gonna get the fact that you work here, here's your phone number, here's your work phone number, here's your work email, here's your assignment.
Right.
And that is all, those are the types of things that they get. And that's that balance of the public's right to know versus an individual's right to privacy. So the public has a right to know, I think, at least the legislature has determined, the public has a right to know if employees that are working for a public entity, if they have been subject to discipline and why they were disciplined. And that's, that kind of balances, that's the balance that I'm talking about. Okay, important FERPA provisions. So FERPA is federal statute governing student data. And FERPA has a similar foundation as personnel data. All data about students is private or non-public unless there's an exception. And there are hardly any exceptions for the disclosure of student data. We'll talk about some of those exceptions, but there's no exceptions, there's only one exception that I can think of for the disclosure of student data to just the general public, and we'll talk about that. There are some exceptions to the disclosure of student data in certain situations. So if the student or the student's family gives consent, then that data can be disclosed. Parents and eligible students, and by eligible students we mean students 18 years of age or older, they can have full right to their file. And if a parent or an eligible student wants to challenge the education data, they can do that under FERPA. So what are some other situations where you can disclose education data without consent? One is if there's an employee in the school that's a need to know. So let's say you've got a classroom teacher and there's another teacher, special ed teacher or someone, paraprofessional or something, needs to know about the student in order to perform the duties of their job, then that would be considered a need to know. They would, that person could have access to the data. Another school or school district, the student transferring, sharing the records with that school, the receiving school is allowed. Again, if there's a court order that requires disclosure, that would be, that's required. And then directory information. And directory information is really the only exception that allows the public to have access to student data. Now, directory information is a situation under FERPA which allows the board to identify data about students that will be considered public. And there's a process that has to be gone through, that once the board identifies, here's what we're going to identify as directory information, you notify the families that the following data is going to be considered directory information, and then the families have an opportunity to opt out if they want. But directory information is usually items such as the student's name, their address, any awards that they've won, their height and weight for, like for example, programs for sports, their, what instrument they play for band concerts. It's the way that I think about it is, it's what allows the school to provide information to Jostens or to school photographers for senior pictures, or again, allows the school to print the program for athletic events or, theater events or, other extracurricular activities. Because if you didn't identify certain items as directory information, then you'd have to go to every student and get their authorization before you could print their name, height, weight in the program, in the athletic program or whatever.
Don't we have a district in trouble right now because they released it to a board member and they solicited all those families?
I haven't heard about that.
This past week.
Well, that would seem to be a violation of that's really not a directory information issue as much as it's probably a violation of the board member's code of ethics, which is using their position of authority for their own benefit.
Potential board member, somebody that's running for school board access to this information.
Oh, well, they'd have a right to do that. Anybody can request it, can request any directory information, and they can request it for any reason. I want to say even creeps could access it if they want it. You don't have a right to ask them why they want it. They have a right to access it if the board's identified it as directory information. So those are situations where where the public can have access to education or student data. So there's some minor distinctions between federal and state law regarding student data. And one is a Tennyson warning. So in Minnesota, whenever you're gathering data from a student or an employee or anything like that, you have to provide a Tennyson warning. We'll talk a little bit more about what that is. So that's one. A minor in Minnesota can provide consent for disclosure of data. It doesn't have to be 18 under Minnesota law. And then the desk drawer exception, some people have argued that, substitute teachers, they don't have a need to know about certain student data. So what's been created in Minnesota, it's called the desk drawer exception. So a teacher can keep notes or information about a student, keep it in their desk drawer, so that if a substitute teacher comes in, they can, see what a particular student is working on, so that the substitute teacher can provide better service. But all those notes and everything have to be destroyed at the end of the school year. So there's no desk drawer exception under federal law. And then, quick thing, under the Minnesota Government Data Practices Act regarding a Tennyson warning. The Tennyson warning is, the reason it's called a Tennyson warning is because the author of this portion of the bill was Senator Robert Tennyson he was the West Minneapolis state senator. But basically what he said, what the statute says, is that any government entity that is gathering data from an individual has to provide them with a Tennyson warning or a warning to let them know what their rights are under the Data Practices Act. So you have to identify, you have to notify the person you're gathering data from, why you're gathering the data, whether or not they're obligated to provide it, the consequences of providing or not providing, and then who else may have access to it. So I use this a lot. Tennyson warning in my practice comes into play a lot when there are employment investigations. So if I'm going to interview a witness, I give everybody I interview, I give them a Tennyson warning. It doesn't have to be in writing. I give it to them in writing, but it doesn't have to be in writing. But the Tennyson warning in an investigation, for example, would say, I am gathering information as part of an investigation of allegations of violations of law or policy. You do not have to talk to me if you don't want to. If you don't talk to me, then I'm going to reach my conclusions without the benefit of information you can provide. If you do provide information, I'll have more information to reach my conclusions. And then other individuals who may have access to the data would be the executive director, the board, legal counsel for the school, the public as allowed by law, any government agency that the school might have to report to. So for example, the Board of School Administrators or PELSB or someone like that, a court that orders the disclosure of the data. That's an example of a Tennyson warning, and once I give the Tennyson warning to the witness, then I start conducting the interview, the witness interview. So that's a Tennyson warning. So when you're asking your students for their information to go in for their emergency contact information, you have to give them a Tennyson warning. We're gathering this information, in case of an emergency. You don't have to provide it if you don't want to, but if there's an emergency, we won't know who to contact. And who else is going to have access to this? The board, legal counsel, EMTs perhaps as necessary, when you go through that. So anytime you're gathering information from students, you have to, students or the public, or employees, you have to provide them with the Tennyson. So some tips, best practices for data practices. There's no requirement that an immediate response be provided. So this happens periodically. You'll get a school will be contacted by a local news organization, Channel 5, Channel 4, whatever. They say, we're going to run a story tonight. We need information on this particular employee. And you get a call at 2 o'clock. We're going to run this on the 6 o'clock news. You have to provide it to us right away so that we can meet our press time. You do not have to provide anybody with immediate gratification. All that's required is that you provide the data within a reasonable amount of time. And the reasonable amount of time is based on all sorts of factors. How much data is requested, how, the volume of data. If it's about one person, the reasonableness is going to be less than if you're asking for data about the entire body of employees. So you just have to respond within a reasonable amount of time. So immediate responses are not required, and in fact, I would never advocate that you provide an immediate response, because that's one of those situations where you ring the bell when you should not be ringing the bell. So immediate requests are not required. Ask for a data request either for students, directory information, or public data about an employee. Ask for it in writing, so you've got a record that you received the request, and so that there's clarification it's clear about what is being requested. So ask for them in writing. Forward data requests to the school's responsible authority. The data practice policy should identify who the responsible authority is. For example, in bigger schools and school districts, usually the HR director is the responsible authority for personnel data. The assistant superintendent or the superintendent or someone who's in charge of, has oversight of the educational program, they're usually the responsible authority for student data. In this school, it could be, are you the responsible authority?
Right.
Okay, so executive director. If there is, if a request for data is made and public and non-public data is intertwined, like someone asked, like on a personnel, for example, on a job application, there's going to be some public data in a job application. Their name, their previous work experience, their previous educational experience, that's public data. So that could be disclosed, but, home address, social security number, other stuff, you have to redact all that. So you want to separate public from non-public data, and that includes surveillance video. So if you have a situation involving like a fight in the hallway or something, and a parent asks for the video, you can show them their student, but you have to block out everyone else. And if you can't block out everyone else, at least under federal law, you don't disclose it at all. That's a little different for personnel data, and if you get to that point, call me and we can discuss it. But generally, you want to try and separate public from non-public data. And then, just so you don't make a mistake, it doesn't hurt to contact legal counsel to make sure that you are disclosing it. And again, because you cannot unring the bell. So better to be cautious and safe than to, just throw it out there and hope for the best. Questions?
It's good, very comprehensive.
And I'm available all the time for calls if they come up regarding these topics and others. But hopefully this has been helpful. I appreciate the opportunity to present tonight. I appreciate the opportunity to be your lawyer. I know you have other choices. I sound like an airline or something. But I know you have other choices, but I appreciate the opportunity to work with you. And
Good.
wish you the best.
Thanks, James.
Thank you.
Yes, let's call for a recess for a quick 5-minute break for people to use the restroom if needed.
All right, good.
We will re-adjourn at 6:55. Yep. We will go ahead and reconvene here at 6:56 PM. So I am up next for the board report. So stepping into this new role, I just want to remind all of our board members of our strategic plan goals. So moving into this next year, the things that we as a board chose to focus on is exercising fiscal responsibility with sustainable growth while maintaining quality facilities, ensuring competitive pay, and appropriating necessary instructional and operational supplies. Providing a safe and healthy learning environment that celebrates our diversity and builds our community. And establishing WLA as a respected destination school in the area, known for high academic achievement and ranked nationally as a core knowledge school of distinction. So I think moving forward this year, we want to make sure that we are exploring options to meet all of those goals that we have set for ourselves. The first one, talking about that sustainable growth. We weren't ready to make a decision if we wanted to go pre-K or high school last year with a new building, but I think it's important that we keep those options in mind and start exploring what growth looks like for us now that we have the space, but doing so in a mindful way that makes sure that we can sustain it moving forward. So just wanted to kind of put that back out there as we move forward, that those are the three things that we as a board decided that we really wanted to focus on. So that's my board report.
Can I add or
Sure.
say something? Just for our first one with fiscal responsibility and growth, we've heard some things tonight from our public comment, and I don't know if we should try to, that kind of relates into that strategic plan. I don't know if we can kind of funnel that into the finance committee to just make sure it's reviewed and that they've looked at the points that were brought up, that we can say we heard the comment, we addressed the comment, and then, how it relates to our strategic goals. I don't know if that's just something we can put on the finance committee or, does that make sense to anybody else?
Sure.
Okay, just so that we're relating that back.
Great idea. All right, that's all I have for a board report.
Great, I will jump into director report then, reminding myself to be short. But as you can see in your packet, I'm afraid there's an error in the second bullet under 2022 MCA scores. It said reading grade 3 is up 20%, reading grade 3 is up 17%, that was reading grade 4 is up 17%. So, as you saw that, some of the good news is our scores have we've made major gains as compared to last year. I think this is a testament to our teachers working hard, our students working hard, and families supporting their kiddos at home. And I think this is nationally, we've all been reading the news, this is a problem nationally with especially catching kiddos up with reading ability. So, as you can see, we're pretty pleased with those gains. And then I have it written a little different with MCA scores are on the rise overall. Also, I wanted to point out to the board that our comparable schools, which are located in District 622, we have been doing really well when you compare us with those schools that we have similar demographics with. On the next page under financial management, I would just add in, I know Brenda's going to go into detail, but we did get approved again for our CEIS grants and our ADSIS grants, and also Title III for the first time. So we joined a consortium with some other charter schools, so we'll have access to Title III funds. And that is all I wanted to bring to your attention for the director's report.
Yes.
They really hard. Okay, all right.
All right, Brenda, we will turn it over to you for the financial report.
Okay, Brenda, we are ready.
We can't hear you.
Hold on one second.
Want me to try to help?
Okay. Let's see. How do you do that first?
Brenda, can you try talking again? Your speaker, increase your volume. Brenda, can you just talk really quick? Okay, I'm sorry. Okay, one more time.
Can you hear me now?
Unmute your speaker.
How about now?
But can they hear online or is that still an issue too?
They should be able to hear online. If I haven't received it, I was, my phone was exploding before, but,
I'll try to sit on my phone with my Oh, now.
so can they hear Brenda or us?
But they can, they've been able to hear everything.
No, they haven't been able to hear it. I didn't know. Yes. Sorry, guys.
How about now?
Perfect, okay, so now we can hear you from the computer, so we'll just.
Okay.
It's really hard.
Tell her to hold on a second.
One second,
Sorry.
Brenda.
One more time. Not out of it. So we're getting closer.
I don't know if you have the process for that.
Let's try to just sit on this.
We should have one of our students come help us run the meeting. They're better at technology than we are.
Mr. Broderick might.
Sorry, thank you.
Try that one.
Okay, one more time.
Oh, man.
Is the volume turned up on the projector speakers?
Maybe we should probably plug it. Hey. When I got here, so.
That helps.
Okay, one more time.
Hi. Brenda.
Now,
Okay, one more time.
yeah. We can hear you, we just can't hear you from the smart board.
Are the smartboard speakers turned on? Oh, that's a thing?
Smart board speaker.
Rich, it's a good time to open a bag of, it's a good time to open a bag of snacks.
I can hear you from my computer, but we just can't hear you from the smart board. So it's really quiet.
So we know it's not her issue.
No, it doesn't sound like it.
I just want to know that in case.
Okay.
Thoughts or something.
Can I try one more thing?
Yes.
Okay, go ahead.
How about now?
We can hear you. We just can't hear you from the smart board.
Yeah. Where is this thing? Volume thing?
My volume's right
That
there.
thing, but usually battery saver, no.
If you click this arrow.
I'm gonna try one more time on this, because it did add. Can you talk one more time, Brenda? No, okay.
I wonder if.
No.
Okay.
I mean,
Okay.
okay. Should we just pause and move on? Okay. Sorry, Brenda.
Sorry, guys. I'll have Justin look into this for.
All right, Brenda, we will circle back to you once we have a functioning speaker. So we will move to the finance committee report for meeting.
Yeah, I'm happy to do it, but I,
Do you want us to go?
yeah, only
Okay, so you
because
can follow.
we usually approve financials for them,
Yep,
yeah, and I
yep.
don't want to approve something on this issue.
So governance committee, you ready?
All right, I will try to go quickly, but please jump in, since we didn't moving pieces. So we met on September 8th on Google Meet at 4:30. We took care of some other little business items, like reviewing 515 policy, just one little update. So that one was included for second reading. We just confirmed that Kathy has completed the MCA requirement document, and that was going to go up on the website.
And then we did kind of our bigger discussion on the WLA, that recommendation to create a policy or amend our bylaws or a process for board member removal. So we kind of looked at just different schools in our area, or schools that we knew had, really updated policies and were really on that. And so we looked at White Bear Lake, MSA, Edina, Shelby School, AFSA. And we kind of just saw what they did for this, or what kind of notes they had. And everybody kind of had their own little ways. Some were very brief, like how ours is, where it can just be removal with cause by a vote of the board. And then we came across Edina's, and they had just kind of a nice outline, or a nice, kind of just, it was just very clear on what things might happen for reasons for removal of a board member, kind of different levels of interventions that could happen if board members were found to violate different roles in their duties. So that's kind of what we discussed, and what we ended up going with was kind of a recommendation towards amending our code of ethics for board members, so not changing our bylaws, not creating a new policy, so just the code of ethics that all board members review when they become board members, and adding just like, for us, it's just ABC, and so it would be letter G, and it would just be informing board members that if they don't follow all the other things in the code of ethics, here's what might happen for discipline if those other things are not met. So I included kind of the example, and this is really just copy and pasted from Edina's code of ethics for their board members. So what I'm kind of proposing is this is kind of a first reading of this tonight. If you guys have had a chance to look through it, and you can kind of read more through it and then submit any ideas or recommendations to the governance committee, and then we'll meet again in October. We'll kind of make sure this aligns exactly with ours, because there's a little bit of verbiage that would need to change for WLA. And then we'll present more of a formal second reading of the amended Code of Ethics document. And then we also just discussed having board members possibly sign this at their orientation, so that we know that they have seen that and they're aware that these types of discipline might occur. But in our bylaws, it would still remain that board members can be removed with cause, and it's pretty plain and simple there. This is just more clarifying for board members, and then we could also have current board members sign that as well, just so we all are on the same page with these points. So I guess there's no really need for discussion right now, but if you read through and you have ideas on kind of what we're proposing for this, please just submit it to the governance committee email, and we'll talk about it at our October committee meeting. So that kind of covers my 5.1 or 7.5.1 and my 7.5.2. And then I guess the other thing that we needed to discuss too at this meeting was we had a few other policies that we looked into, so I can briefly look over those. So we looked at 413, which was harassment and violence policy, and we just want to make sure that's up to date. So Kathy's gonna look through that, and we're gonna enter that into first reading, just with our growth and role changes, making sure that everything is aligned with how big we are now. And then we discussed the role of committee chair. So Jess Erickson has been committee chair for the last year, but she's just looking to take things off her plate that has got fuller this year. So I offered to fill that role, so that will be my second motion of the night, so that's something we discussed.
Thank you.
And then we discussed policy 801, which Jess will be reviewing and bringing back to the committee for recommendations. And that's already been posted for reading. And then 806 and 807, we'll kind of wrap up those at our October meeting too. And then we have some items for future discussion as well, just based on some things that have come up in the start of the school year. But other than that, I'll just kind of wrap up my minutes and then make the motions for the pieces in the agenda. So we do have our meeting scheduled for October 13th. That would be our regular time and day, so 4:30. It does say location on here would be on-site and Google Meet. So we have some people who meet on-site, but then we have the open Google Meet too. There's a possibility we will reschedule that one just with some scheduling things that have come up, but we will post that 3 days prior on the website, if that changes. Otherwise, we adjourned at 5:27 PM. Any questions about the minutes or things? We're set. Okay. So then my first motion is to accept September Governance Committee minutes, enter policy 413, which is harassment and violence, into first reading, and policy 515, protection and privacy of people records, into second reading.
I will second that.
Right, there's been a motion and a second to accept September Governance Committee meetings minutes, entering policy 413 into first and 515 into second. Is there any further discussion? All in favor, say aye.
Aye.
Opposed, say no. Any abstentions? Motion carries.
And the second motion will be to accept the resignation of Jessica Erickson as committee chair and seat myself, Natalie Schilberg, as the new governance committee chair.
I'll second that too.
All right, there's been a motion and a second. Is there any further discussion? Okay, all in favor, aye.
Aye.
Opposed, no. Abstentions? Motion carries. See if we're connected here.
If not, I can do facilities, it's pretty quick.
All right, we'll move on to facilities for Mandy.
Okay, our facilities committee met on September 13th. Jolene was out of town, and so she was unavailable, and, oh, actually, that's not yours. Sorry, this is Jason's. Sorry, that's the other committee that you're out of town. Facilities committee, we were all present, and Jolene's no longer on. So, sorry, Jolene.
That's good.
The certificate of final, like our certificate of occupancy, we've been waiting for a long time for our final copy, and we did receive that. There was a long list of things they were trying to button up and T's they were trying to cross, and that has finally been received. So we received at the beginning of September, and that was long awaited, and we're very excited. Working on, you're going to hear this in both facilities and finance, but as the project is winding down, there's some extra funds in the project fund. And if you guys remember, long ago, we signed a resolution to be able to reimburse any funds that the school has spent related to the project out of the bond fund, should there have been money there to do that. And there is some money there to do that. So admin has been working the finance team has been working really hard to submit receipts and move some of those funds to the general fund to reimburse the school for any expenses incurred. So that is underway. And there was just some more discussion, no decisions yet, but more discussion on ideas for the fields across the way, whether it's pavilion, a sports court of some sort, an older kid playground. I don't know if you want to elaborate on there, but I don't know that there haven't been necessarily any decisions at this point, but just kind of further discussion and just on what the needs of our students are and the best way to meet those needs, and what that would entail and look like.
No, I'm good. I just need to talk to Jolene about pickleball courts and bigger kid playgrounds, and we really need to get that laid out and then budgeted, phased in.
Non-related to the fields, can I ask a question?
Yeah, sure.
About the new facility and completion? There's a few loose ends that still need to be buttoned up as far as some seals on some doors.
Okay.
And some of the locking mechanisms.
Yeah.
Is there still work being done, with people still coming out kind of thing?
Yeah.
Okay.
Who's the best person to give that information to?
Mr.
Ben?
Broderick.
Okay, so if you could tell Ben, and then Ben
Yeah.
can work with Roshan to
Right.
Yep.
get some of those things buttoned up.
Sure.
Yep.
Thank
And I
you.
gave you your dates for Curtin and MEA. I swear I sent you an email.
Yeah, Julie is also serving on that,
Yeah.
so.
Yep.
Sound system, sound buffers, curtains, stage lighting, some seals. There's a few things yet to be done.
Right. Yep.
I swore I sent you an email saying they were doing an MEA weekend.
Somewhat. Just the sound system.
Sound system, yes.
Mhm.
That I sent.
I did get that.
Okay. Sound and curtains.
Oh, curtains too? Okay.
That's what they told me.
Nice.
some things, but I swore I did that thing.
Yes.
Okay, so with that, I'm going to make a motion to accept the September Facilities Committee minutes.
I'll second.
There's been a motion and a second. Is there any further discussion? All those in favor say aye.
Aye.
Opposed say no. Any abstentions? Motion carries.
I have another option, Cassie and Ben. I could log into Zoom from my computer and we could use the sound so that we could kind of hear better here.
Yeah.
You just have to mute yours and then I can move that closer to me so that people online could hear, especially since there's no one in the crowd right now. I think it was
Yeah.
harder when there was more people to need to hear. So let me just try to do that real quick.
Brendan, can you unmute, just try talking one more time? Sorry.
Yeah.
Okay, we can hear you. We're gonna get logged in and let the board hear you on their end, so just give us a little moment and
So I do know there will probably be feedback if you're not on mute. So if you want to mute and then we'll see, oh, you know what? You're logged in as me.
I think you can still log in.
You do?
I think, try it. I think there's just two Mandys, because we've done that before.
I hit
You and
join
I.
or new? New.
No, just however you would normally go
Okay,
into
new I
it.
would do, but,
What's the meeting ID?
Yeah,
oh,
there.
yeah, okay. So
You're in?
I'm gonna,
Yeah.
Recording in progress.
I'm gonna stop that real quick. Or maybe, oh, I probably can't.
You just have to say yes.
Okay.
Mute your speakers.
Hey Brenda, would you mind unmuting and speaking?
Sure, can you hear me?
Read this.
Where's Ben's? Yeah.
Ben,
Okay.
Hi.
Can you guys hear if you put, will financials go up there still?
Why do I hear myself? Oh, because I'm.
I think what she's,
It might be okay when Brenda's talking. If it's just me hearing double, I just won't talk.
All right, can you hear me now?
Yeah.
Rich, can you hear her well enough? Okay.
Can you hear me now?
Yeah, we can, Brenda. Cassidy, can you still put the financials up on there? Perfect. Okay, Brenda, I think we're ready.
All right, sorry for the hassle.
Oh, it's not your fault. It's on our end. It's okay.
All right, I'll try to make this quick. I know it's getting late. We are 2 months into the fiscal year, August of 22-23. And so I'll go over the summary of the key indicators here. We know the original budget was at 724 for an enrollment projection. We are working on a working budget currently to determine that working budget, ADM budget, but we have an actual ADM of about 680. So we're working with the administration to get that balanced, and we're pretty close. The budgeted surplus for the fiscal year was about 255, and we were going to be spending about 7,500 out of the community service fund, and so that projected fund balance would have been at about just shy of 2.3 million, or 29% at the fiscal year end. So next month we will be presenting the working budget and how we have gotten that to balance with the new enrollment. Our projected days of cash on hand are 103 days of annual expenditures. So strong cash-wise, well above the required bond covenants. Financial key points. We're only 2 months in, so about 17% complete for the year. Our cash balance is at about 2.1 million, up slightly from last month of to just 2 million. That's because we have received one of 3 large holdback payments, but paid back from last year's fiscal 21-22 holdback funding. And so the cash balance will continue to go up for the next couple months because we'll also receive a big payment at the end of this month and the end of October. And we've also received lease aid payments here. The lease aid was approved on August 1st, and so we're also receiving lease aid payments. Our state aid receivable balance for 21-22 is still at $103,000. So that's the amount of money we'll be getting here in the next 2 months. Revenues received year-to-date are at 17%. Expenditures are about 9%, so a little under year-to-date trending, but that's very typical at this time of year because we're only 2 months in. A lot of those invoices start coming in September. Again, our lease aid application was approved on August 1st. The school's annual audit for last fiscal year was held this week, and today was the last day of that audit. So, so far looking really good, and looking at a strong fiscal year ending position from last year. And then we'll be presenting the working budget next month after we kind of get that solid enrollment into the budget. The next area of the financial packet is the colorful dashboard data. And so you can see that we'll start to track the approved budget and then that working budget. And right now they match because we haven't changed anything because at the time of the financial report, we hadn't determined exactly what those final working budget numbers are. So we'll have those ready for next month. In the second area of the report, we'll tell you where our budgeted revenues and expenditures are at. Now, fund balance history. You can see that our fund balance did grow a little bit from last year, fiscal 21-22. Those are unaudited data yet, but we are growing. We did have a surplus last year, and we are continuing to grow the fund balance. And then the financial trends, you can see that revenues are just a little over and expenditures are under. And you'll see that how that compares in a straight line from month to month. And we don't have enrollment yet. We usually start tracking that on October 1. October 1 is kind of the date where we start reporting that fall enrollment data. And so we'll start tracking enrollment numbers here when on the next financials. And then there's a cash flow projection. You can see how August is a peak and then it will start coming down in September and October. But it's a slow arc and then it comes back up. So looking at the balance sheet, the beginning numbers in the left column are the unaudited data. And so keep in mind these were as of the beginning of September here. We just finished the audit this week. So some of these numbers did probably change a little bit as we were preparing financials. And so next month we'll have a little bit closer number to those audited data. Here's the biggest number on your balance sheet is the cash and investments at 2.168. You can see like right now we have due from the building company, some funds due from the building company, about 103,000. State aid receivable for last year is at 200,000, and the current state aid receivable for the current year now, they're already holding back funding, the 10% holdback is 171,000. Revenues exceeding expenditures as of the reporting period was 646,000. This next page is the statement of revenues and expenditures. And at the top is where we indicate where we're at, about 16 to 17% through the school year. So that's a good indicator of where you should be at this point in the year. With the state aids receivable estimate, we are at 17% for the state aids. And of course, next month, this year will be adjusted here up in this column. The second column in will be adjusted to reflect any changes that we're making to that enrollment. Federal funds, federal funding is only received is only about 5%, and that's because a lot of these programs are not spent down yet, but we have to spend these funds before we can draw these funds, so there's always a little bit of a delay in those funding. A lot of this is related to staffing and after-school programs and summer school. Now, local fees. We're actually a little bit ahead of the budget here. We did get some extra local grants, and so some of these working budgets will reflect that in the next month. So we're at about 117 of the current budget, but we will be adjusting some of these local grants to reflect those, that budget coming in. So total revenues earned are $1,346,000. Down to the next page, we have the expenditure summary. And you can see that there's some of the expenditures are a little ahead of the straight line schedule. And those are typically areas like postage, supplies and materials, and insurance and so on. And those are all very typical at this time of year. And all pretty much in line in where we should be year to date. And towards the bottom here, we should reflect all the expenditures for the federal programs, and those are just ramping up at this time. The school just starting. So our total expenditures are only about a 9.1%. We'll probably see a lot more activity in the next month. So total expenditures were only $700,476 for that net income of $464. Now, if we stayed on this trend, we'd be at a 29% fund balance. But again, we will be balancing the budget to make sure that we're still in line with those these typical benchmarks. This next area of the financial statement is just the cash flow projection, and this just anticipates where we are going to be receiving those funds and the holdback for last year, and where we're estimating some of those expenditures to go through, and we'll continue to update this as we go through the year. Very strong cash-wise. And then this next page is a summary of our contracted services, and you can see that kind of last year where we ended up and where we're going this year, fiscal year to date. And not a whole lot of activity yet. But there will probably be a few changes in this area too as we go into the fiscal year. And that's the end of the financial packet. And not a whole lot of activity yet. Will be more updates for the next month. Does anybody have any questions?
Brenda, sorry, I know I have her. Did you happen to hear the public comment tonight? Do you have any thoughts on that?
About the lease aid?
Mm-hmm.
Well, the thing about any budget is that it's driven by enrollment, and your lease is set based on enrollment projections, and so the best way to balance your budget, they are projections, and the best way to balance your budget is to make sure that you're aligning your expenditures with your revenue, and the general fund would have to take on more expenses if you don't have as much lease aid. But then working on those, working on maintaining student and working on that enrollment growth is the best way to deal with it. And there's always ways to balance your budget by reducing your expenditures. If your enrollment is down, a lot of times they're offset by expenditures like staffing. If you don't have the enrollment, then you don't need the staffing, and a lot of times that makes up for the additional expenses that you're having to pay for with lease. But it's not uncommon, and it's very it's with oversight and working with the budget. It's not it won't be hard to balance the budget. It becomes a little bit more challenging, but it's doable.
Thank you.
Mm-hmm.
I'm gonna shut my Zoom off. But you'll still be on Cassidy's if you're hanging on. If not, we'll see you later.
I'll circle back up to the finance committee report.
Yeah, give me just a second.
I guess if Brenda addressed the public comment, then I don't know if the finance
If I need
committee
to
does.
assign
I
it.
mean, the finance
Oh,
committee.
I mean, we're gonna
can
continue looking at, that's what we do every
Yeah.
month, that's what we do. So, it's okay, it's just that is what we do. So, you can definitely delegate it to the finance committee, because that is an every month conversation.
Yep.
So, okay. All right. The Finance Committee met on September 15th virtually, and we spent a lot of time talking about the financial statements for August, the ones that you just saw. We definitely are aware of the enrollment trends and are trying to do what we can to minimize expenses so that we can maintain a balanced budget and so that we can continue to meet our debt covenants. I just want to maybe specify, I mean, we are experiencing growth. So we did add students, we're just not at the rate that we had originally predicted within the bond offerings. So I'm not trying to diminish that, I'm just saying that we are aware of it and are working through that. So we will continue to work through that. It's hard to know sometimes at this time of the year until you really know what students show up, it's hard, you make these projections, but then until school starts, so it's very typical that there's some kind of budget amendment during the first couple months of the year. Usually it's October. So we will continue looking at, we do every month anyway, but we will stay focused on that. So, and then the second point on the minutes here does actually just address the same thing I addressed in finance. We, as a finance committee, in facilities and finance, we're looking at those reimbursements that we could potentially send to the bond fund to get reimbursed for any monies that we had spent on the building to go to our general fund, which will, again, just help with the situation we just discussed. So, that is all. So I'd like to make a motion, and find it, to approve the August financials and the September Finance Committee minutes.
Second.
There's
There's been a motion and a second to approve August financials and September committee minutes for the finance committee. Any further discussion? All those in favor say aye.
Aye.
Aye. Opposed, say no. Abstentions? Motion carries. All right, we get to jump down to one of the last things on our agenda here. Point 8, board discussion of the EDIAM. So do you want to read this? Do you want me to read this?
No, I'll just give a little reminder to board members that the EDIAM is usually the superintendent or the executive director of your school district, and it allows me, in this case, to give access to others that may need to go in the systems, such as Bergen KDV or Cassidy for entering data on enrollment and so forth. So it's the person that gives permission to other people to access some secure systems at the Minnesota Department of Education. The EDIAM board resolution will have to be read. It is very specific, has to go in this verbatim. You have it on your screen if you want to make the motion.
perfect.
Or somebody else does.
So when I make the motion, then I read this?
That's your motion.
All right.
It's a long one.
I would like to make a motion. The Minnesota Department of Education, MDE, Professional Education or Educator Licensing Standards Board, PELSB, and Office of Higher Education, OHE, require annual designation of an identified official with authority for each local educational agency that uses the Education Identity and Access Management System. The IOWA is responsible for authorizing, reviewing, and recertifying user access for their local educational agency in accordance with the State of Minnesota Enterprise Identity and Access Management Standard, which states that all user access rights to Minnesota state systems must be reviewed and recertified at least annually. The IOWA will authorize user access to state of Minnesota education secure systems in accordance with the user's assigned job duties and will revoke that user's access when it is no longer needed to perform their job duties. Our school board or equivalent governing board must designate an IOWA to authorize user access to state of Minnesota education secure websites for our organization. This EDIAM board resolution must be completed and submitted to the Minnesota Department of Education annually, as well as any time there is a change in the assignment of the identified official with authority.
And I think you can stop.
Yeah.
And that's your resolution.
I'm gonna just add on, just like, so the board recommends to authorize Kathleen Mortensen to act as the identified official with authority for Woodbury Leadership Academy.
Yes. Do I need to
And then
say
I'll second.
Okay.
So I'll amend the agenda to include that. I'm sorry, not the agenda. I'll amend the motion to include that, and then maybe someone else can second.
I'll second.
All right, so there has been a motion and a second. Is there any further discussion? Great. All of those in favor, aye.
Aye.
Opposed, no. Abstentions? Motion carries.
Okay.
Board communication and future items. They are no longer here, but had public comment tonight. We will delegate that public comment to the Finance Committee to continue to look into our financials, making sure that we're staying on track.
And to respond.
And to respond to Ryan Patrick,
Directly?
or just at the next board meeting.
It should be,
Like a public
within
comment?
5 to 10 days, a brief email.
Okay.
I can help you with that as one of the people that attends the Finance Committee.
Okay.
Do we need to discuss committee roles for Richard
Oh,
at a
yeah.
future meeting?
Yeah.
So,
Richard, you can give some thought. Yeah, you can give some thought about which committee you think, if you have capacity to join a committee. It's not necessarily a requirement, but it's good to have that knowledge, so you can think about governance, facility, or finance.
Okay, is that something I should think about
Yeah,
for the next meeting?
yeah, yeah.
Let us know your preference.
And
Yeah, and if you all can give me some direction on where the need is.
Yeah, true.
That kind of help me as well. I mean,
Yeah.
I don't have a strong feeling
Yeah.
towards either.
Yeah.
But if there's a need in one versus the other, I'd rather
Yeah.
fulfill the need than personal preference.
We also had one of the other individuals that expressed interest in filling the parent seat that wasn't selected. We had said, we love to have more people, as many people could help as we can, and so we had suggested maybe a committee role, and so he'd followed up asking him, again, same kind of thing as Richard, which committee needs help and where can I be of assistance? So I think it's both helping Richard figure out where we can best use his talents for our school, but then also one of the other individuals as well, so.
I feel like governance, it's nice to have
Yeah.
other opinions, even if they're listening for most of it, and then just, I know Erin Newman does a great job of that, just kind of jumping in when she has insights. So, I mean, that's somewhere that I feel like it's nice to have more people insights into the policies too.
Policies are for someone that is real detail-oriented and likes really getting into the weeds. Facilities Committee is fun.
I'm not a detailed person.
Finance is if you want to learn school finance better, or if that's kind of your zone.
That's probably my zone, 'cause
Okay.
I'm really good at math. But like I said, I'm more interested in the need of the whole versus, just trying to fulfill what I'm.
I love that.
So,
Very nice.
yeah, I'll think about it and
Okay.
definitely discuss next week. I'll just top two.
Okay.
All right.
All right. Any further discussion or topics? All right, so our next meeting will be held on Thursday, October 27th, 2022 at 5:30 PM here in this room. Would anyone like to make a motion to adjourn?
I'll make a motion to adjourn tonight's meeting.
Second.
All right, there's been a motion and a second. Further discussion? All in favor, aye?
Aye.
Opposed, no?
Except I don't get to vote.
Motion carries.